Okay, today is November 17th, 2017, and we're at the lakefront campus of University of New Orleans with the Midlo Center discussing the legislation that passed in 1976 in the Louisiana House. Mr. Robein, could you please tell us your full name and occupation?
Louis Robein. I'm an attorney and a graduate of what was then called LSUNO in 1972, and a graduate of LSU Law School in 1975, and immediately went into the practice of labor law in 1975, right before the passage of the Louisiana Right to Work law.
And Mr. Babin, could you give us your full name and, again, your occupation? Well, I know you're retired now, but
Semi-retired.
Yeah, my name is Peter Babin III, and I followed my dad's in his footsteps in becoming a member of the International Union of Operating Engineers in December 6, '56. And later, through the course of my experiences, I wound up becoming business manager for the Operating Engineers, Local 406 for the state of Louisiana, for 30 years before I retired in 2005.
so you became business manager at or near the summer of 1976 or 75?
76.
76. Okay. We've heard this phrase, right to work. And I guess it's appropriate we're discussing this today because throughout the country today, it seems that we're seeing more of this legislation being proposed throughout the country. But in 1976, Louisiana was the only so-called right-to-work state in the South.
Correct.
And Mr. Robein, can you tell us, or Louis, can you tell us what does that legislation mean?
The term right to work is really a misnomer. It's been referred to as right to work for less. It does not provide any right to work, any guarantee of employment to anybody. Essentially what it means and how it's been construed by the U.S. Supreme Court and the National Labor Relations Board and by our own Supreme Court is that no employee in Louisiana, no employee in the private or the public sector can be terminated, disciplined by an employer because of his or her failure or refusal to pay union dues. And essentially what it does is it outlaws what is called a closed shop in other parts of the country, where unions negotiate basically mandatory dues, that if you're covered by the contract and you're protected by the contract and you're represented by the union, everyone in the shop pays union dues. This law outlaws the mandatory enforcement of any union dues requirement, service fees, union dues, whatever, but it only regulates employers. That's important. But ultimately, it has far deeper political and economic implications because it's basically been viewed throughout the decades as a signal that any state or local authority that adopts a right-to-work ordinance or right-to-work statute declares itself anti-union and anti-worker. And that's how it's perceived, and that's how it was legislated, and that's how it was lobbied.
So essentially what you're telling me, if I understand it correctly, is that a worker can be employed and be governed under a union contract but not have to pay for those benefits under the right-to-work laws.
That's a fair statement. That's correct.
Okay. So, Pete,
I think it goes a little further than that. In fairness to my counselor, who was my lawyer for years, what it also does, Roland, is that the union has certain obligations under the labor agreement, particularly as it relates to its trust funds for providing health coverage and pension coverage, apprenticeship and training. And also, they have an obligation on fair representation to represent an employee in a right-to-work situation that's not a member of the union to represent them fully. through the whole aspect of agreements that they have. But in doing that, it costs the organization a lot of money because we have to minister the health and welfare through our trust funds. We have to minister the pension program through our trust funds. We have to minister the apprenticeship and training on our trust funds. And we have to employ all the people who are in that category of work providing them services. And the individuals who's not a member receives the wage rates of the labor agreement, receives the benefits that I just described, and pays absolutely nothing for them. To me, that's a big issue.
And what Peter's describing is the right to freeload. It basically codifies the right to be a freeloader. You get the benefits, and when Peter refers to the organization, he's referring to the majority of employees, again, public or private, that stuck together, obtained recognition from the employer, collectively bargained, and administered, and as Peter pointed out, then administered not only a wage program, but a very valuable medical plan, pension plan, vacation plan, and the like. All those individuals, if they want to, under the right to work law, can exercise the right to withdraw their membership and get all those benefits for the full term of the 3 or the 5-year contract and pay the organization that got them, their fellow workers. They have the right to freeload.
Now, the recognition of unions inside of plants or construction contracts largely came from national legislation under the Wagner Act.
Correct.
And then some years later, I guess, in response to the
1948.
Wagner Act,
48.
I was going to say 47 or 48. I couldn't-
48.
Taft-Hartley
Right.
Correct.
comes into being, which tries to change some of the rights that were given to workers and
Correct.
unions. As a result, that's this right to work law or legislation takes its form around that time period.
It was a carve-out. It was a carve-out primarily for the southern states.
And as I appreciate it, Louisiana originally passed this legislation, the right to work legislation, on around 1955 or so.
Correct.
And then it was repealed,
Around 56, 57, yes.
and there was an effort on some continuing basis to introduce a legislation every year, every few years after that. Is that
Correct.
okay?
Correct. It never went away.
So the climate in 1975, 76 that gave rise to this legislation passing, the work climate in Louisiana. Can we first start, and let me ask you, Peter, what was the status of workers in Louisiana at that time in terms of had wages grown, had benefits grown? I mean, not every worker was a union worker at that point.
Well, in the construction industry, which I'm most familiar with, parallel to that time, we had a tremendous expansion of petrochemical industry on both sides of the river, from New Orleans to Baton Rouge, and then skipped and went into Lake Charles. And because of that, there was tremendous amount of expansion and new construction in the petrochemical industry. Under the labor agreements we had nationally, as well as local, contractors that came down, Roland, notified us that they had a job. We used to call a pre-job conference, and we used to sit there and work out all the arrangements before the job started and went to work. So you ask, what is the presence of? It was pretty much all union work, and right to work definitely had an impact on that in later years. But the work situation was very good, and we had a lot of employment. Okay, and it was primarily all union employment, particularly in the construction industry. They might have had some small operations, light commercial stuff, and that kind of that kind of work that maybe small contractors who didn't sign the labor agreements with us perform the work as non-union. But basically, the great majority of the bulk, I think you agree to that, Lou, the great majority of the bulk, particularly in the petrochemical industry, where you had to have skilled, very skilled trade union employees doing the work, was primarily union.
And we refer to that term skilled workers. Can you give us a little idea of what a skilled worker truly is?
Well, in the case of my trade, when you're operating heavy equipment, particularly cranes, and you making major lifts, weight lifts, you have to be extremely careful, and you have to have knowledge of the ability of that piece of equipment to perform that work. So we go through an extensive training program to make sure that those members who eventually become crane operators go through a series of training sessions and then have to pass physical tests in performance at our training sites to be certified as a crane operator. Operating engineers known in the industry as a service trade because we service in all the other trades with our equipment, other than dirt equipment where we're moving dirt. So we have other people's lives in our hands and our responsibilities when we make a lift with a crane, and we setting it somewhere. There's either iron workers or boiler makers or electricians or pipe fitters or those trades receiving that material, and we have to be extremely careful that we don't hurt somebody. That's been our slogan in the history of my organization, operate safety first, safety first. And so to say training, that's basically what we're talking about. They really have to know what they're doing. They have to have experience, prior experience, on-the-job experience, and total experience, okay?
So the apprenticeship programs that you were talking about earlier that your organization ran, that's what you're talking about in terms of you just don't take someone off the street, they have to go through a program.
Prior to that, just a second, prior to that, before the apprenticeship programs were put in place in 1973 with the operating engineers, we had a classification called an oiler. And his responsibility was to make sure the machine was greased, and it was cleaned and fueled and everything else. And he worked under the tutorship of a journeyman crane operator. And so when things were a little slack or something on a job, the operator would let that oiler get into the machine and get familiar on how to run it. And eventually, through that on-the-job training, OJT, which we call, allowed that oiler to develop into a crane operator and run a piece of equipment. That's how I learned, because I came on before the apprenticeship program.
So in 1975, 76, what is going on in the Louisiana legislature? What's the climate in the state in terms of this legislation being introduced and moving forward? Louis, you want to start with that?
Well, at that time, Peter had just come aboard as a business manager, and I had just come aboard as an attorney. But it was clearly in the historical literature that will show that organized labor had gained great strength and influence within state and local government, be it Lake Charles, New Orleans, and prior to 76 and leading up to 76, the Louisiana Association of Business and Industry had formed, and was essentially, if you look at the interviews and historical history, Lobby was attempting and did succeed in creating a business model, so to speak, within the legislature and state government that mimicked what then President Victor Busey of the state FLCIO had worked 20 years to build. Very powerful, influential lobbying and grassroots organization throughout the state, Shreveport all the way down to New Orleans. diligently appeared before city councils, then police juries, and ultimately the legislature or the executive branch, and lobbied very hard and strongly with the support of the rank and file for various improvements that affected both private and public sector workers in Louisiana. And well, all you have to do is look at all the so-called reforms implemented by former Governor Jindal and before him Governor Foster, many of which affected this educational institution that were directed towards rights for teachers, tenure, rights for public employees, as we see most recently in Louisiana with this, New Orleans with the so-called Great Place to Work initiative. All that, it's been decades of attack on worker organization and worker rights. Tenure is a perfect example. We're sitting in an institution where tenure means something. That is the product of organized labor, that protection.
So we had more workers moving into middle class in the mid-70s, Peter?
Oh, absolutely, okay. I don't want to talk about when I got started, because if say what I made in those days and what's happening now, it'd be ridiculous. But the truth of the matter is that I can recall when I first got into the organization, my dad was an agent in the office, along with the rest of the leaders of the organization, used to negotiate contracts, and this was in the early 50s, where it was a 3-year contract for 15 cents. Okay.
That was a lot of money then.
Yeah, 2.5 cents. 6 months, 2.5 cents, 2.5 cents, 2.5 cents, 2.5 cents. So we worked for 3 years for 15-cent raise. Okay. And
but with a pension.
Oh yes, with a pension. Okay. And the health programs just got started. But as we grew, like Louis said, as we grew, and our membership increased tremendously from those days until into the 60s and the 70s with the boom in construction work in Louisiana, like anywhere else, we was able then to negotiate better wage rates. So to answer your question, the difference between working union with all the benefits and working non-union with no benefits and less wages, and that's how they get to say right to work for less, was the differential was so great it was absolutely pathetic. So then you could buy your car, you could hopefully think about at the time buying a home. Now you can. Recreational purposes, maybe go on a little vacation. I had to take my children to Disney World one time, okay? And other things, fish and hunt, that we like to do in Louisiana. That basically you couldn't do that before because you didn't have the luxury, you didn't have the money, and you didn't have the time.
So in 1976, were there any independent events that led up to the legislation being advanced? Were there any outside independent labor events that assisted this legislation from moving forward?
Well, there were certainly job site incidents, Jupiter Chemical being the most significant, in Lake Charles, where there were, we'll call them picket line incidents, where there was picket line violence, non-union, affectionately referred to as scabs, crossing picket lines, protesting the fact that a particular job was being worked outside of a collective bargaining agreement on a non-union basis. And there were some confrontations, and in one case there was a death. And that, obviously, that makes the news. Made the news big time down here. It made the news, throughout the state. And it was used. And it happened. It was good timing, bad timing. It happened. Also, the murder of the chief lobbyist for Lobby,
Right.
Jim Leslie, in the parking lot of the Prince Muskrat, about 2 blocks from where I was living as a law student. did not help the situation.
Let's talk about that for a second, because I've read some accounts of that, and it appears that at the time they were trying to relate, or the stories accounting of it, they were relating this this death to the legislation itself.
Which it just passed.
Right.
Okay.
Blame the unions in a lot of respect for having participated.
And was
What
there,
happened?
Was there any truth to that? or-
Absolutely not.
None.
Despite the fact, living in New Orleans at the time, seeing Phil Johnson on WWL every night, blasting organized labor for the murder of Jim Leslie, actually being in a meeting with the governor, who expressed some trepidation about vetoing the legislation because of this incident. I mean, that's the reality. It turned out that the gentleman was assassinated by one or more, what was then called, and today would be called, a biker, who traveled down here looking for him, killed him, and ultimately, through criminal investigation, the murder was tied into to those bikers, who then ratted out, essentially, the former chief of police from the city of Shreveport. Jim Leslie was testifying against the former, in a corruption case.
So the lobbyist who was murdered during the session when this bill was passed was a witness against the chief of police in Shreveport at or near this time.
Correct.
And it had nothing attached or to do with labor activities.
No, of
None
course not.
whatsoever.
Okay.
None whatsoever.
So let's talk about,
But they were blamed.
they will blame.
Sure.
Let's talk about the momentum for the legislation itself, because I think, Peter, you had mentioned earlier, and so did Louis, that we had a climate where benefits were increasing, workers were coming into the middle class, and unions were having more resources available to them to engage in better lobbying and in governmental relations. So why couldn't those resources prevent the passage of this legislation?
Well, Louis alluded to it earlier. The disturbances had a lot to do with it, okay? But Vic Busey, who was then the president of the Louisiana FLCIO, developed a very effective lobbying organization. I served on that group, in which he put together an elaborate system where we would look at bills that pertain to organized labor in whatever sector of organized labor existed, and people were specifically designed in the office to follow that legislation from the beginning of introducing to the legislation till the final vote. And we knew who was doing, okay? We were right on it, okay? And Ed Steimel, who I think was with Cable or something, Lou?
Yeah.
Cable for a Better Louisiana or
Yeah.
something, saw that effectiveness. And that's when he left Cable and decided to become head of the Louisiana Association of Business and Industry,
Correct.
what is known as LABI. And he basically adopted the whole thing. And he used that effectively against us. And in doing that, he showed the situations that Louis was talking about with the bad experiences that we had in Lake Charles and in Baton Rouge one time, and twice in Lake Charles, where there was a murder, okay, that never could be, no one was ever found to be guilty because they couldn't identify it, but there was shootings going on. A bullet went through
A trailer.
a trailer and happened to hit somebody, and he died. So all that apparatus of those disturbances, and they were serious disturbances on job sites, and using that along with the things that he developed of what we did as lobbyists through the program that the president of the FLCIO became very effective. And I'll tell you how effective it was, because I can recall we used to do a questionnaire that we used to send out to every person running for office, whether it's in the Senate or the House of Representatives. And it was a series of questions that was asked strictly pertaining to labor issues. And one of them was, would you vote to repeal right to work if elected to the Senate? Or if you was elected and you was running back, would you vote to repeal right to work? 95% of the legislators who answered that questionnaire said no. They would not vote to repeal it.
So-
That was prior to the vote, and they all voted to repeal it. Well, I say not all, but the great majority voted to repeal it. So that's how that thing flipped, Roland, okay?
So, but we're talking about the passage of it for the first time, Pete, in 1976.
Okay.
Who were the floor leaders that you had for labor at the time, and what was going on? Where did this bill start, in the House or the Senate?
It started in the House.
I think so, yeah, maybe. I think it started in the House and then went to the Senate, okay?
Yeah.
Okay, so who were the floor leaders that labor had, or in their business had at that time? Do you recall?
The floor leaders labor had,
Yeah.
Vic Busey was the perennial leader of us as the president.
He's talking about the legislators.
Oh, the legislators? Oh, the leaders in the legislature at that time that we had. Anthony Tony Visage was a member of the House of Representatives from New Orleans.
I'll help you out. Who was-
Okay, go ahead.
Sammy Nunez.
Sammy Nunez.
Nat Kiefer.
Not you,
Ted Hickey.
Ted Hickey,
Sidney Bartholomew.
Sidney Bithami,
Mike O'Keefe.
Michael Keith. That's the Senate side he's talking about, okay?
And the House side?
Well, it depends on what area, but from New Orleans, the greater New Orleans area, I mean, it varied. It was Charlie Grisbaum, Charles Zulo, John Ilario, Diana Bajois, Avery Alexander, Ben Baggert, Lane Carson, Ron Fauché, Johnny Jackson, Manny Fernandez, Rick Tonry.
Rick Tonry, yes.
And these were all labor-friendly
Some of them.
allies?
Yeah, they flipped, some of them flipped.
Ben Baggert certainly wasn't.
Yeah, yeah, he flipped, okay. Lane Carson's,
Yeah.
he flipped later on, okay.
Young Morrison, Toni Morrison.
Yeah.
So, tell me a little bit about what was going on in the legislature when it would come up to vote. I assume, in addition to Mr. Busey testifying in front of these committees, that there were other people coming to testify.
Did you testify?
I testified, no, I didn't. I testified later on prevailing wage rates in Davis-Bacon.
So, when the House gets ready to vote on this is right after the July 4th break. Is that correct, or am I not remembering this correctly?
May have been earlier.
Yeah. I don't think July break, because the legislature convenes in early spring, March, April, and it usually finishes around June. It's a 90 days, it's a 90-day, 30-day, 90-day, 30-day session. One's legislative session, 90 days, fiscal sessions, 30 days or 45 days, something like that. It's been a while since I've been up there, Roland.
So tell me what your recollections were at that time, Pete, as it was coming to the vote and when the votes are being taken. You're obviously up there lobbying.
We had what we call a tick sheet. That was the expression we used. And when we would go lobby certain representatives or senators, right, during that discussion, when they were debating it, they would give us an answer, yea or nay, or I'm still thinking about it. And we used to mark down on that tit sheet who we had and who we didn't have. And my recollection recalls that the tit sheet that we had said that it would not pass. The repeal would not pass. And we were very confident. But again, relating to what Louis said, at Steinmel and Levy and the forces that were opposed to organized labor, really did TV stuff.
Well,
everything.
that was a big deal.
Yeah,
I mean, that was
yeah.
Leslie's role. This is
Yeah.
the first time they really went
Yeah, right,
viral with the media.
right,
Today would be social media, then it was television.
right.
And they certainly had the support of various so-called editorial staffs, like Phil Johnson in New Orleans.
Right. And the heat got on them. The heat got on them big time. And like Louis relating to it was very effective down in the community with the voting base. And they started to express their views about organized labor. And in the last week of the session, when the bill was coming up, they flipped, and we lost those commitments, and that's how it was repealed.
And what was the vote? Do you recall?
It was close.
Yeah, it was close.
Just like the attempted modification in 1992, it was like
Right.
5 or 6 votes.
Right.
Mhm. But to answer your question, quoting from a very nice report from 2006 on the murder of Jim Leslie by a family friend, the debate lasted all day in the state Senate, and you could cut the tension with a knife as I sat in my seat in the Senate. By a slight margin, Louisiana's new right-to-work law was passed the Senate, you're right, in late afternoon on Wednesday, July 8, 1976.
Yeah, okay, good, all right.
Jim Leslie was killed a few hours later. And then the article goes on to tie it into his former relationship with the Shreveport Public Safety Commissioner, George Dortois.
I'll never forget, Roland, I was lobbying Senator Michael O'Keefe, who was a young senator at that time, and became very prominent in the United States, in the state Senate. He was the president of the Senate. And I asked him, I said, Mike, I said, what are you gonna do? He said, Pete, he says, I can tell you, this is the easiest vote I'll ever make as a state senator on this one. I said, well, that sounds good, but tell me what you're gonna do. He says, I'm gonna vote not to repeal it. I said, okay.
But to go back to what you said, it really, the issue came out of the construction industry because construction was booming, and the complaint from the business council, so to speak, whatever they called themselves
It was the
back.
Chemical Association.
The Chemical
big one.
Association.
That was the big one.
is they wanted
Danny
they
Bond.
wanted the flexibility to hire out-of-state, non-union workers, transported in from Texas primarily. That's why Lake Charles plays into this picture.
And what was the advantage for an employer to bring in out-of-state, non-union workers?
Well, the camera will show me this. Non-union wages, no fringe benefit obligations, no union hiring hall responsibilities where they would be required to hire locally through a union hiring hall, local workers. They wanted the ability to have a mobile workforce that would go state to state, traveling workforce. That was a big deal back then. And
No
still
jurisdictions?
Yeah.
No, basically no jurisdictional restrictions where a worker, if he had the ability to do the work of other trades,
Right.
he could cross trades on any given time during the day or doing a job, which denied those that was in that trade who didn't have the trades of the others, another opportunity not to be able to be employed.
So this ultimately impacted local communities because you would have out-of-state workers coming in.
Right.
And they were transient in nature. They were designed to be transient in nature.
Correct.
Is that?
Correct.
So after the passage of this bill, you mentioned that there was an attempt to meet with the governor for a veto. Could you share any of those discussions that you were participated in?
I can. Hello. I think you can too. Hello.
Yeah.
I think yes, Governor Edwards was the
Now,
governor.
because we're in a different time, it's Governor Edwin Edwards.
Edwin
Oh, yeah.
Edwards,
We've
Governor
had a couple of
Edwin
Edwards now.
And
And he's still alive.
and he's still alive. And he was asked the question, if the right to work bill passes, will you sign it? And he said yes. My opinion, is that I didn't think it was going to get passed. Okay, that's my opinion. But it passed. So then we had rallies. I brought hundreds and hundreds of members to Baton Rouge to lobby the governor to veto it. I think the final analysis, you correct me if I'm wrong, Louis, I think the final analysis was that the shift was so great from where those legislators' records were so strong for organized labor to where they voted to repeal right to work. I mean, to initiate, pass right to work was so tense and so strong that we came down with a final decision that if we did that, it could very well be introduced as a constitutional amendment and be placed in the Constitution. And in order to delete a portion of the Constitution, you had to have 75%.
And remember, there was a constitutional convention going on at the same time.
Yeah, right.
Yeah.
So it went from a simple majority to repeal it back to then a constitutional question of amending the Constitution, which would be 75% you need. So that became an onus thing on our part, and so we opt to say, let this get over with and see if we can come back later like we did before and repeal it.
So
Or modified.
Or modified, right.
what
Which
was
we
the immediate impact of this legislation in 1977, 78?
It was political. It was seen as a successful attack on organized labor and its strength in both Baton Rouge and in local communities. But economically, it took a while. As Peter pointed out earlier, the petrochemical industry, for those employed directly by the petrochemical plants, they were then and still remain significantly organized. They're union shops. And there hasn't been that much movement within those, even when these companies, whether it's Exxon, Shell, they're reconfiguring themselves as this and that, but they stay as quote-unquote union shops, the petrochemical industry. And for that matter, the docks, the stevedoring industry is primarily a unionized industry. But it's in the public sector, there's large segments of unionization, teachers, firefighters, police. There was no immediate impact, but over time there was, because of the political impact, the political meaning of right to work. It's a signal to workers that this is an anti-union state.
Right. There was another aspect to that too, also, Roland, that traditionally we had collective bargaining agreements where we negotiated, we signed for a period of years. 3 years was the norm.
Right.
And the law, the repeal, didn't. The right to work law didn't supersede that labor agreement.
For 3 years.
For 3 years. So if someone, for example, if my organization just had entered into a collective bargaining agreement for 3 years, then those contractors that we had that agreement with worked under that labor agreement until that term was ended. But any new contractors that came on and received work, then right to work legislation immediately affected. So it was like Louis said, it was a slow drain for a few years until those expiration dates of those collective bargaining agreements expired. Then after that, it became a major impact on the work that we used to be under labor agreements. We
And
used to have, we lost.
It also led to the only piece of legislation that then young Governor Buddy Romer was able to get through the legislature was the repeal of the prevailing wage law.
Right.
That was the next major move. It authorized the state and local governments when bidding work or procuring work to do so with the requirement that contractors or vendors that provided the service would pay the equivalent of a federal prevailing wage. In other words, minimum wage and benefits. That was a natural transition to get rid of that.
So if I understand the prevailing wage law, it's an offshoot, it's I think they call it mini Davis-Bacon.
Correct.
Right.
And Davis-Bacon was the federal nomenclature
And still
for it.
is.
And what it meant was when they were bidding a job, they were supposed to determine what the prevailing wage for an individual community would be,
Correct.
so that public works jobs, workers would get that prevailing wage.
Correct.
And the public facilities that would be constructed, we'd have local workers. Presumably, you'd have local workers getting that prevailing wage. Now, Peter, is that how it worked?
Yeah, it's ironic, Roland, because when right to work was repealed in '56, Herman Edwards was a state senator. He voted to repeal it. Okay, but he made that mistake, and he said that if it passes, I'll sign it. Well, right after that, what Louis is talking about, Buddy Romer got elected governor. As a matter of fact, there was a runoff between Buddy Romer and Edwin Edwards for Edwards' second term,
I think so.
and he took a position saying that if the incumbent can't run first, he can't win, and he decided not to run, and Romer got. But then in Romer's administration, it passed prevailing wage. It failed.
The repeal.
The repeal. It failed prior to Edwards' thing, but it passed later, and it impacted my organization terrifically because of we were allotting roads and bridges and a lot of state financing,
money.
state monies. Where in the petrochemical it was private monies, and I went to see him, and I had a nice talk to him, and
When you say him, who?
the governor. I went to see the governor right after the vote was taken. As a matter of fact, when the vote was taken, Sergeant at Arms in the Senate called me and said the governor wants to see you. And I went over to the mansion where his office was.
And this governor is Governor Romer at
No,
the time.
this is Governor Edwin Edwards. Okay,
Okay.
when it passed the first time to repeal Davis-Bacon. That was before Romer came on.
It was defeated.
He was defeated.
Yeah.
And he asked me to write his veto message, and he vetoed that one. Then Romer got elected, and then that's when Romer passed it, and he signed it.
Well, tell me how they would determine what the prevailing wage was in a community.
But looking at the union wages, the highest wage.
Well,
Yeah.
you're my lawyer, but it was a survey. You're supposed to provide a survey to the Department of Labor, and that survey would determine by putting all the wage rates together, what was paid in the industry. The survey was determined to be what the prevailing wage is. What Louis is saying is correct. It was the union wage, and you know why it was the union wage? Because the non-union contractor wouldn't submit how much they were paying their workers. Okay? So they never did submit surveys. And we submitted our surveys all the time.
Because they couldn't document the fact that they were paying W-2 wages.
Right.
They were paying cash.
And that's how it became the union wage rate. But technically speaking, prevailing wage is supposed to be what is the wages prevailed. And the United States Department of Labor does a survey, and where everyone's supposed to submit who's in that industry, how much they pay their workers, and then it's put together, and the equivalent of what's equal is what the prevailing wage is.
So, as we sit here today, on the public facility construction projects in our communities, they are no longer paying the prevailing wage.
On the state and local side.
Yes.
Federal jobs,
Right.
except for FEMA granted. They,
Okay,
Yeah.
well, let's talk just for a moment, because we're talking about the impact of the long-term impact of the right to work legislation. And what I understand you telling me is that from 1976 to roughly 1985, 86, when Romer gets elected, there was a steady trend downward for union contracts and for employee wage increases. And then when prevailing wage gets repealed on a state level, we have a further downward trend for local workers to receive a prevailing wage, as well as local workers even getting positions
correct.
on state and local jobs.
And remember, we were younger then, but you will remember that in 1980, someone named Ronald Reagan was elected. And a lot happened on the national scene, but on the local scene, construction industry went down the tubes. I mean, because of the economy. I mean,
Right.
there was and so all of wages were going down, benefits and wages were going down simultaneously because of severe economic impact on the petrochemical industry in Louisiana.
I negotiated contracts, Roland, where there was no increase in wage rates.
Right.
None whatsoever.
Yeah. The 80s were a horrible time.
Right.
So I had heard the phrase double-breasted contractors. Was that phrase at all as a result of right to work or prevailing wage, or?
Let me take that one.
Yeah, I will let you do that.
Yes. That was a very sophisticated industry, not just in the construction industry, but it was a very sophisticated method of diverting union strength, so to speak, by creating alter egos, or what was then called, and still is called, a double-breasted entity. Ultimately, the tactic was ultimately upheld by the U.S. Supreme Court in the Peter Keywood case.
Help me understand what that really means.
What it means is that you'll have, say, a controlling company, a parent company, that could create, will already own and control Company A, which has historically worked union millwrights, whatever, and hired union and was then and continues to be signatory to a collective bargaining agreement. But the company could create a separate legal entity, and we as lawyers know how to do that, LLC, whatever, just set up a separate corporation and divide the control of labor relations to the extent that it could be shown, if ever challenged, that the labor relations, employment relations, are separately controlled, that the head of the operations on the union side does not do the hiring and firing on the non-union side. Just create a barrier, a fictional barrier.
Could coexist.
Yeah. They coexist, doing the same work.
Right.
And the difference in wage rates for individuals on these jobs, can you give me any idea of what the...
Back then, and even today, as the man or woman in the field would say, the money in the check is the same, sometimes more on the non-union side. But where they're saving, so to speak, where they're cutting, is on the fringe benefit side. They're not making pension contributions, and critically today, they're not providing, as they may be required today, they're not providing through the employer mandate on the Affordable Care Act, they're not providing health insurance. And they're not providing the other fringe benefits like vacation plans that Peter's Locals had historically and training benefits.
Right.
They're not providing that. They don't have to pay for it. And today, that fringe benefit package could be as high as $10 to $12 an hour. So they'll take literally, well, not literally, but I mean, while the wage rate may be $25 an hour, they'll pay those non-union workers $25, sometimes more take-home money. But they get away from the fringe benefit obligation.
It's called total package. That's
Right.
the expression we use, total package. The wage rates plus the cost to provide the services that Lloyd was talking about, apprenticeship and training, health coverage, vacation coverage, pension coverage, is added to the wage rate. So that's called a total package. So they only paid with the wage rate, didn't pay any of the total package. And like Louis said, that could be today, it could be $10 an hour. Well, if someone is bidding a job and you're gonna put 300 or 400 workers on a particular construction job, and the non-union contractor who's bidding that work has a $10 an hour advantage over the union contractor, and it becomes significant. It could become very significant, particularly on public work.
With no prevailing wage
No prevailing
requirement.
wage, public
Yeah.
work bids, low ball, gets the job,
Yeah.
you know? So it became a headache, to say the least.
The benefit packages that you talk about, typically when you would negotiate those on behalf of your workers, Pete, would the employee also contribute to his pension as well as the employer, or was just employer contributions?
It was, when we negotiate a wage rate, it's up to the members to determine how they want that wage rate to be
Allocated.
to be allocated. So if they, let's just be hypothetical. Let's say it's $3 an hour wage increase. They want $1 to go into their pension, they want 50 cents to go into their health and welfare, and something to go into training, whatever that $1.50 and whatever is deducted from that $3. So basically, they get that amount less on their check, but they pay for it. That's the twist about the whole thing, because the contractor only becomes the conduit of sending that money to, by virtue of our trust agreements and contribution rates, to send that money to the trust funds to be administered by joint labor management trust committee. But it's really the wages of the worker. So it's not something that you negotiate and then the contractor puts more on his own on top of it to pay for something. It's a deduction from the total package that is negotiated.
So, in closing, what would you like to have a closing statement on this right to work legislation? What you think, how it impacted our workers, positively, negatively, in the state of Louisiana, and where we find ourselves today? Louis, would you like?
Well, as just summarized, a right to work law is a symbol in any state or in the federal. It's a symbol. It's very symbolic, and it leads to other things. And in this case, it led to the repeal of local prevailing wage, and ultimately, in my opinion, led to the modifications or repeal of teacher tenure protections and civil service protections for public workers in the state of Louisiana. Ironically, the mini right-to-work provision that was put into the state constitution in 1975-76 was actually flipped around by the teachers in Houma, and the Supreme Court applied it literally, unlike on the federal side, and said right to work means the right to be non-union or to be union. And it was flipped on its head to protect striking teachers in Houma and elsewhere. Again, it's symbolic. It means you only have the right to be union or non-union. But it leads to other things, and it gives comfort, so to speak, to anti-union, anti-worker legislators and governing authorities that feel that the trend or the attitude in the state is that unions are discouraged. Worker organization is discouraged. And we're about to see that in the U.S. Supreme Court coming out of the Illinois case. It's a question of whether or not unions have a place in our economy. And the opposition says no.
Also, Roland, I think it served as a philosophical impact from the political side of the spectrum to say contractors don't have to worry about the political influence that labor unions have in a particular state, like in Louisiana, so they can go out on their own. And you know, the primary source of a construction labor union is to have a pool of skilled craftsmen to service the needs of a construction contractor, because it's not like a steady job. The job starts, you service the job with skilled people, the job's over with, contractor either bids another one or goes on his way. The workers come back to their union halls for future employment. What it did is it diluted tremendously that skilled pool that the trade unions had to supply to contractors. And in doing so, it lessened their impact of having those skilled people. I use the term controlling the market. Might sound like it's a tough thing, but that's the fact of the matter. You controlled the market where you had the skilled people, so they came to you for the skilled people, and you negotiated a labor agreement that was acceptable. Right to work took that away, and it diluted that. And so it weakened the unions across the board, and its tentacles spread out to other areas in the workplace outside of construction that Louis talked about. A perfect example is just recently, the state of Wisconsin voted right to work. The state of Michigan voted right to work because they were attacking the teachers' unions in those states, okay? So that's where the pinnacles are reaching out from the start of the construction industry to the other areas of employment, whether private or public, throughout the United States. And like Louis says, there's going to be an issue before the United States Supreme Court to have a blanket right to work status for the whole United States, just like they did in giving Taft-Hartley 14B?
Yeah.
14B, Amendment of Taft-Hartley, which gave states that ability to opt out of a union shop. Now the Supreme Court wants to give that same provision to the whole United States, even superseding a local state that says, no, they don't want to do that, superseding it, and that's going to be a big issue.
Thank you all so much for your time.
Thank
Okay. I think that